Good evening, gentlemen, ladies and gentlemen. Mr. Khorwal has covered a large portion of the bill as such and its provisions, so I will not repeat all those things and try to restrict myself to other aspects which I feel need to be considered and discussed. So, one of the key features, if you see, is the Ministry Department shall not limit participation of bidders or discriminate against amongst bidders except for the protection of public order and morality, animal or plant life, intellectual, national security. This implies that the foreign companies can also fill up tenders without trouble, and that is what EU, USA and all have been pitching for. So we are getting into an era where now foreign companies will also be, they are in global tenders, but in all other tenders also they will be able to freely participate. Some of the things which need to iron out and still looked into, it's in a bill form, is like one of the provisions they have that there will be redressal committees under the chairmanship of a retired judge. The magnitude of procurement and the number of tenders which government department and PSU has would be numerous. And I am not sure you have so many retired judges available to do this work. So there can be a bottleneck. If the committee has too much work, then all complaints coming, unless they clear it, it is not reaching finality. This is a bottleneck which needs to be addressed in the rules or by amendment as such. Further, the intent of having a High Court judge alone, whereas procurement is a specialty of business, those interest groups also could be included in that. That way the government would have a bigger pool to deal with the issue. I hope since it's still under consideration that the rules may cover this aspect. Then we have different codes and procurements and all. That is, we have already gone through punishments. The bill states different degree of penalties for offences such as taking bribes in respect of procurement, interference with the process, making vexatious, frivolous and malicious complaints and other offences. Now here is a catch actually, because you are pitched against industry and they have a machinery to fight. So whether there would be complaints, there are in the present system, of course, complaints are there and some would be there also. But then if the penalties of imprisonment and heavy fines, so I'm not sure whether people will come out and complain so often. That is constrained as well, because when we are going for public procurement and open, then there should be an opportunity for the people to complain freely also. Of course, there has to be robust mechanism to deal with the issues which may come up in times. The procurement methods have been mentioned, which are in fact already in use. We have open competitive bidding, that is already in use in government. Restrictive bidding is also there. You have a panel of pre-approved parties. Two-stage bidding is also part of it. The single source procurement is in the case of OEMs. And this is in fact nothing new. This is what already is happening in the government. The difficulty or the conflict, I would say, is coming section 23, like no price negotiation. This is today also as per CVC guidelines, But the difficulty comes if there is a cartelization. It's not very easy to prove cartelization. And you have assessed that the price ought to be lower. You are restricted to negotiate. This circular has come by CVC because this was also used as a method, to extract benefit from the parties. But nevertheless, on the other side, it works against the industry. Then we are elaborately dealing with the standard procurement of BHEL is having turbines, they want to buy turbines, all right, bigger items. And NTPC projects are there, key turn projects you can have, that is very, very much there. But then there are PSUs who are also in the trading. There is no area in the bill as of which is addressing the trading companies. There is a vacuum here. We have a mandatory 21 days CVC guideline. The purpose is that parties get time to quote, evaluation they will make, and then they will quote, so there should be a minimum time prescribed. But when you are in trading, you are dealing with commodities which are determined by international prices, and you open a tender in 7 days or you open in 30 days. Mind you, the price would be linked to the international price of that product. So it's no use going through all the process in that. Another requirement in trading is the decision has to be very quick. Unlike construction and other projects, the window is open for 2 hours or 3 hours. That day only you have to decide, or maximum you give 3 days time to a party where a decision needs to be taken. In the process here, if a single complaint comes, you are restrained from placing an order. And when you are not able to place an order, virtually you have discarded the tender. So these are some of the aspects which trading companies have also taken up in their suggestions, which government needs to consider. So in my perspective, there are a lot which needs to go into it. It's a very good initiative. It is required. But there's a lot of thought which needs to go into it to cover more. Or alternative could be in some areas we have carved out some exceptions so that other companies can also deal with it. Thank you very much.
Thank you, Mr. Sharma. Now we can have some questions if anyone of you is.
Sir, I read somewhere there was going to be a localization clause that 30% of whatever order you get, you will have to procure material from within the country. So is there such clause in the act or the bill, sorry?
No, that's not a specific clause, but this is a set-off principle which government is already following defense procurement and aircraft procurement, the set-off policy where the company who is selling you aircraft or defense equipment, they have to a certain percentage, which varies, they have to invest that money into a given projects, that is development of product, technology or related to that. This is their commitment, and there are companies designated who follow it up. It is already existing. It is not part of this. Maybe in the rules they are going to cover it.
Purchase preference they may give.
Purchase preference, yeah, that's a separate.
So any more questions?
So more often than not, we see a lot of corrupt activities going on from either of the parties. Let's not say from one of the parties. Can the bill do something about that, or?
See, bill is addressing by having deterrent punishment clauses a means for doing that. Only thing is that enabling rules have to be done well, because without them we are going to have 1 year of vacuum, because bureaucrats are not going to take a decision on procurement when they know that 60 lakh rupees of product I am buying and 6 months is the minimum imprisonment if the complaints are there and issues come up. So the enabling rules have to be drafted very well. That also encourage procurement. Transparency should be maintained, but it should also encourage procurement.
When do you see the bill turning into an act? Sometime next year? I don't see it happening this year though.
Some of the issues Mr. Khorwal has flagged, some of them I have said, and there are many more which industry has raised. So government needs to address them before it becomes law.
Thank you.
I think it needs to be relooked, because there are a number of, procurements, different type of procurements are there, and they are reviewing it.
Is the government able to reject all bids?
Yes, in the present system, recording the reasons in writing, government can scrap a tender. That a bid would the scrapping means that it amounts to rejection of all the bids.
I'm sorry, I have a lot of questions to ask, but I think I should be asking on behalf of the people sitting here. We recently saw a case in the Competition Commission of India wherein the Ministry of Commerce and Industry had advertised to procure shoes of certain sorts, and those shoes, the shoes we wear, had to be made of a certain material, rubber shoes basically, and this was last year, and the tender was advertised, and when the bids started to come through, one of the person who was dealing with the tender saw there was a very identical sort of bidding documents from the parties. So the stamps were placed at a certain level in all the documents. The signing was at the same level with a certain ink, with 10 different parties sending the document. The pen was the same. The mistake, the typographical errors were the same, and so it thought to send this to the Competition Commission, which actually comes under the Ministry of Corporate Affairs, and when they started to investigate, the SMEs were the parties who were trying to outsmart the government, actually. Said we actually didn't knew about the Competition Commission. That bid rigging is one of the offences under the CCI Competition Act, and but the fantastic thing is that the CCI did not levy a single amount of penalty. This is a SME sector, and this is for the first time that we see this type of cartelization, so we are letting it go. But this is very different from the other type of cartelized activity in a procurement set, in which the CCI has levied a lot of penalty.
See, I flagged cartelization because it is a reality, and they are of many types. One is where you decide the bid amount. Other is where you divide the regions.
Market allocation.
Right. You have Amron batteries, Excite batteries, Raja batteries. There are 3 main suppliers in the country. So matter has gone to Competition Commission there also, that they are cartelization. They have divided the country into 3 territories, and the L1 bidder is one particular in that region, and the other is in the second and third. So it is a sophisticated way of cartelization. And the crude way is a group of people, suppliers, they sit in a room and over a glass of beer, they decide what to fill up.
Recently, I had a friend sitting along with me, and she said, I have to run to office. I said, what's the problem? You know, there was a conference going on. I said, I have a client and I have to draft the procurement tender. I said, what? How do you have to draft it? Said, they have a connection with the government. The government has asked the party to draft it on its own favor, and then that would go to the government so that it gets benefited. So you see, it's a lot more complicated and sophisticated than what us think about the whole procurement process.
Yeah, the process is indeed complicated, and that is one of the reasons that you want to have a law on that. Only thing is, while drafting and finalizing that law, I mean, due care has to be taken off that we are able to cover most of the sectors. And some exceptions have to be made because under a single system, it is not easy to work. The engineering side, the civil side, the procurement side, the trading side, there are so many sides to involve to it. So all stakeholders' interests have to be protected. So there has to be some exceptions which will have to make. They will have to make.
Thank you so much.
There was a recent controversy wherein it was all over the media that the Honorable Prime Minister said that the policing and policy making have to be differentiated. The issue where it came to tenders for the mining recently. He was abroad also, I think, when he said that. And the follow-up was given by Mr. Chidambaram also. My question relates to the reaction to the existing regulatory agencies to this bill when it comes in force, as to how are they going to adapt to such changes that we're talking about.
See, that is to be seen, you know, how the Parliament decides to set the system through the enabling rules, right? I mean, that's what is the concern we also feel here. But with regard to the Prime Minister's statement on that contest, I would say you are all aware about the spectrum issue, right? So there was